All right, welcome to another episode of Trial Attorneys. Thank you for tuning in. My name is Shay Allen.
Ricky Granderson.
We have a very interesting issue today, an issue that fortunately comes up often. Looks like Unc is in trouble.
Unc, yeah.
Yeah, Shannon Sharpe. He has a lawsuit.
Unc stands for uncle.
Uncle.
Yeah, that's what we call him Unc.
They call him Unc.
Mm-hmm.
There's some serious allegations that have been lodged against him. And we're going to talk about this because it's an issue that I think arises often. I think it's an issue that is going to continue to be pervasive in today's society because, quite frankly, victims are speaking up. So first of all, we're going to talk about the facts because facts are important. So we start there, and then we'll get into our discussion of this because as the trial attorneys, we're going to give you the facts. And then we're going to talk about the actual legal reality of the case, as opposed to just talking about what happened and making up random opinions about that. In regards to the lawsuit, it was filed on April 21st, 2025 in Clark County, Nevada. The plaintiff has filed under a pseudonym of Jane Doe, so she hasn't used her real name as of yet. And the defendant, the person accused of the wrongdoing, is Shannon Sharpe, former NFL player, current ESPN sport analyst.
Is he in the Hall of Fame?
He is in the Hall of Fame. He wasn't just any NFL player.
Exactly.
He was a very good NFL player.
Yes.
The claims are sexual assault, battery, emotional distress, and invasion of privacy. A claim regarding secretly recording intimate encounters between the plaintiff and the defendant in this case. The damages sought, over $50 million in damages. So the allegations from the plaintiff are this. The plaintiff claims that a relationship with Sharpe that began in 2023, during which the alleged incidents of sexual assault occurred. In particular, it says in January 2025, the plaintiff alleges that Sharpe refused to use a condom during sexual activity despite her objections. October of 2024, the plaintiff alleged forced sexual acts, claiming that after ending communication with Sharpe, he confronted her and engaged in what she describes as non-consensual sex, and then recording and sharing. The lawsuit alleges that Sharpe secretly recorded intimate encounters and shared the footage without consent, thereby violating her privacy. The plaintiff claims that Sharpe's involvement in an Instagram live stream with another woman played a role in her distancing herself from Sharpe, contributing to her emotional distress.
Really, this comes down to the issue of credibility.
Right.
I consented or I did not consent. And I think the most powerful thing you can speak on that is depositions. Mm-hmm. They're going to be able to ask both sides, if I was the defense attorney, all types of some of the most personal questions because these are some very personal accusations.
They are.
So you gotta search everything, but it's a credibility issue.
Right. Well, for me, I would work on attacking this particular allegations. I'm not really a big fan of going to media and the court of public opinion in that matter for attacking or bolstering credibility of someone. Maybe if it's a case where you want to get the public on your side because someone was wronged in regards to a civil rights case or some kind of employment discrimination or something to that effect, fine. But for this, if I'm the attorney on either side, well, if I'm defending Sharpe, I want to look at the exact allegations of what they're accused of, and behind the scenes, I'm going to be doing my investigation. So nowadays, there's such a digital trail of everything. Text messages, emails, social media, DMs.
I don't understand what people don't realize. Once it's out there, it's out there. You can't take it back.
Well, I think people realize it, but they just don't think anything negative is ever going to happen from it.
Yeah. So
they just communicate freely because they don't think their personal information is ever going to get out. Even people who have fame, fortune, and or money, they still, for some odd reason, don't believe that these things are going to happen to them.
But it's similar on the criminal side when you have police officers who have body-worn cameras, and they know they're being recorded, and you'll be amazed at some of the craziest things they say because they're so already comfortable that camera is there. So it's really the same thing.
Yeah.
We've seen police officers say racist things that shows that the accused is innocent. But in this case, looking at the lawyers from the plaintiff's side, I'm trying to figure out, why would you bring that information out? Mm-hmm. And that places Shannon Sharpe's attorney in an awkward position. I mean, till this matter comes to trial, do you want the world just to hear her side, be bombarded with her side? Sometimes you have to make a difficult decision. Well, should we take this opportunity to respond? Because potential jurors are only hearing her side. Mm-hmm. So I think that's a choice that you have to make. Do I respond to it?
Yeah, that is a choice. So Sharpe has strongly denied all the accusations, calling them false and part of an attempt to extort money from him. His legal team statement, Sharpe's attorney, Lanny L.J. Davis, has labeled the lawsuit a shakedown and stated the claims are baseless. Criminal sexual assault in the criminal aspect is a very difficult allegation to defend. Of course, we dealt with several types of those cases over our careers.
From both sides?
From both sides, yeah. And just like with any criminal case, you're really looking at holes, or you're trying to dispel the other sides or the other versions' story of what happened. So you're looking for inconsistencies. You're looking for instances that just are impossible, things that just don't make sense. And of course, credibility is going to be huge. We call it veracity, but credibility is going to be huge for the complainant in these cases. Are they believable? And when saying are they believable, because whether people want to agree or not, human beings lie. So we've seen instances where complainants who are accused of someone of sexual assault, they have completely and utterly lied.
And I think, unfortunately, society has, everybody wants to protect victims.
Sure.
And it's become fashionable to attack people who say, some of them are not victims. Yeah. And that's the reality of the matter. And we have to accept that. And then the issue here is she a victim or not? First thing that jumps out at me is that, what you're alleging are vicious criminal, we'll call them rape. That's what it is. The old term is rape. And first thing in my mind is, why didn't you charge him criminally? Why are you going after just the money? Why didn't you do both?
Yeah, because legally it's possible. These allegations are fairly new, 2023 in a legal sense. So that is a good question. Why hasn't he been, or has he been investigated? We haven't heard anything about a criminal investigation.
Well, normally if there was a pending criminal case, they would put the civil case on hold. But my thing is the fact that you don't, and you have these attorneys ask charges be made, but you're going after the money. So the question is it about the money?
Well,
that would be my argument.
Well, most civil cases are about
the
money.
What I'm saying is, but it makes more sense to me. You're saying that you're a victim of a criminal act.
Absolutely.
And you want that person to be criminally punished. Mm-hmm. Then after that, you want to be made whole again through the civil case.
Absolutely.
But when you just go straight to the civil case, it gives the appearance that that's what it's about. It's not being victimized. Right. I'm just talking from the position of the defense attorney.
Right.
That it appears that it's about the money. Mm-hmm. It wasn't horrible enough for you to go file criminal charges. You skipped over that, and now you're going after the money.
Yeah. So Sharpe released a public video on his social media channels asserting that the relationship was consensual and that he had been falsely accused. One thing that came up in this case as well, too, the text messages have been getting released.
What do you think about that, just releasing potential evidence?
I don't like it at all.
It doesn't make sense to me.
But then again, we're actual trial attorneys. You know, like I said earlier, I don't like to try my case in social media. The place to try the case is in the courtroom. And maybe my viewpoint of that is old-fashioned. But I don't like the releasing of text messages, audio recordings, evidence, possible evidence that will be used in the case. And it looks like recordings are being released from both sides.
It's like tit for tat.
Right, yeah.
Because the only people you're going to have to convince are the jurors.
Yeah.
Not the public.
Yeah, but it's similar to the theory you said earlier. Yeah. You're trying to reach possible jurors, people who will see this information and make up their mind before they even come to court, which theoretically not supposed to do, but that's how human beings work. Mm-hmm. That's how human beings work. Okay, so the case is gonna be an ongoing process here. We're just way in the beginning stages. Both sides, gathering evidence, preparing for the discovery process. So the plaintiff's legal team has released an audio recording where a man, allegedly Sharpe, makes comments that the plaintiff's team believes support their claims. And of course, Sharpe's legal team has argued that the audio recording was taken out of context. It has nothing to do with the exact allegations.
To my family, friends, supporters, and colleagues, I want to speak to you directly and from the heart. This is a shakedown. I'm going to be open, transparent, and defend myself because this isn't right. This is all being orchestrated by Tony Buzbee, who has targeted Jay-Z. Tony Buzbee targets black men, and I believe he's going to release a 30-second clip of a sex tape that tries to make me look guilty and play into every stereotype you could possibly imagine. That video should actually be 10 minutes or so. Hey, Tony, instead of releasing your edit, put the whole video out. I don't have it, or I would myself. You know what happened, and you're trying to manipulate the media. The encounter in question took place during the day at her invitation, and now that appears to be a deliberate setup, coordinated by Gabby, also known as Carly, on OnlyFans. Gabby and Tony Buzbee want $50 million. What they're getting is sued for defamation and trying to take me down. My career is all about real talk and honesty. I know my family and fans know exactly what this is about. And I'm going to be out there telling you whatever I need to say, just like I always do. I love all you guys. Thanks.
Like I said, I primarily practice criminal defense, and we both were prosecutors. I think it's insane to get your client to get up there and make a statement, because it may come back to bite you in the behind. That's what a lawyer's for. The lawyer should get up there, and anything the lawyer says won't be held against the client.
Yeah.
And a lot of people don't realize, and we've experienced, even the most minor thing could be twisted in a way to make you look bad.
Yeah.
And then now you're almost locking yourself in your trial strategy. If you're saying that this is racism, the white female victim versus the black man, you haven't gotten all the evidence out. Right. Don't lock yourself into a theory of your case, and it's a real bad decision to have your client get up there and say that. You get up there as the attorney, and you say it.
Yeah, I think it's a horrible, 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 if I haven't made it clear enough, horrible idea to have your client make
horrible.
Yes, horrible. To have your client make these public comments. If you don't know, anything that a person says, especially in criminal prosecution, can be used against them in a court of law. So any comments they're out there making can be used against them, and inevitably they're gonna say something that hurts them. I don't care how sharp you think you are, how smart you think you are, how verbose you think you are, loquacious. You're gonna screw yourself. To be honest,
and that's what lawyers are paid to do, to take something that looks harmless and turn it into something bad. And here's another thing: some people may look at the video and say, "Oh, I don't believe him."
Yeah, well,
by what he's saying, how he's saying.
The reason I don't understand having your client speak out in public in that way is because, first of all, everyone knows it's a prepared statement. So I'm speaking from the heart. No, you're reading something. Everyone knows it's prepared. Somebody put it together. They
may hold that against you.
Yeah, you practice it, and then now you're here saying it now, so it's not from the heart. But even if it is, so what? I mean, whether they're going to believe you or not going to believe you. But I think this all points back to the fact that I don't know Shannon Sharpe's attorney at all, but he's doing things I wouldn't do, and but I think a lot of times it boils down to if these attorneys are actually trial attorneys, have they done trials? How many have they done? How many have they really been in the trenches, or are they just out there poking their chest out saying that they have?
What a good example is with the Donald Trump, suing certain law firms.
Mm-hmm.
There was law firms that conceded to his wishes. Those were just, real estate, blah 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 type of firms.
Right.
But then when he went after these other firms who were trial attorneys, they like, oh no, we're taking you to court.
Yeah.
So there is I'm not trying to knock anyone, but trial attorneys, they look to fight.
Yeah, and also it was a short and brief statement, but there are a couple things I just really didn't like about it, even though it was that short. When he's saying he's coming from the heart, if you have to tell someone you're coming from the heart, it's probably not from the heart.
It's like saying, I'm not a racist.
Yeah, or
if you're not a racist,
or saying
tell me.
or I hate when people say to tell the truth. Should you always tell the truth?
Exactly.
I mean, I don't understand why you got to tell me you tell the truth. Just tell the truth. And then he attacks the plaintiff's attorney.
That's not a good idea.
Why are you going after this attorney personally? That's weird. I mean, this attorney is the problem? I mean,
well, now let me ask you a question. He had to go over his statement with his attorney.
right.
So that means he gave the okay
Yeah.
to attack the plaintiff's attorney. Not a good idea. It's
Yeah.
not about the attorneys.
Yeah. And then finally, I don't think I agree with the whole race angle for this yet.
That's what I was thinking.
Why is this some attack on black men? I don't know. What does having sex with some woman have to do with being a black man? I don't get it.
See, that's why I'm saying is, we don't know what the truth is,
No.
but as an attorney, don't lock yourself into that.
Right.
Now, when it comes to trial, you may switch up. You may turn around and say, you've played this videotape. You said this was a race thing. Now you're saying it's this.
Right.
So,
Yeah.
and I think attorneys watch television. I watch television.
Mm-hmm.
And I think they're locking themselves into television law versus just the basics. Always the basics, the fundamentals always work.
Absolutely. And I've represented high-profile cases and clients in the past. And my advice, even though some of them don't like it, is to be quiet. Shut your face. Be quiet. Let me do my job.
That's what they're paying you for.
Mm-hmm. Let me do my job and go somewhere and be quiet. People, especially because of social media, people just have this inclination. It's almost like a child. A lot of times I find small children, if you accuse them of something, they always, but I didn't do it. It wasn't me. Even if it was, I didn't do it. I didn't do it. Sit back, let your attorney do their job, and don't say anything.
It's more dignified too.
Right.
I mean, you have all types of clients, highly educated and uneducated. A lot of times they say stuff that's stupid. It doesn't matter, and your job as an attorney is to present you in the most positive light.
Right.
I mean, remember we had the one case where our own client objected? That's our job.
Yeah.
It happens. So we know what we're doing. And I would never have my client, whether civil or criminal, make statements. It's going to bite you in the behind.
It never goes well. It never goes well. So, people, a lot of times the clients can be forceful. Well, I want to make a comment. And my advice, I always tell them, my response is no. Don't do it. Bad idea. It's going to fail. I don't care who you are. It's not going to go well for you. So just be quiet and let your attorney do what they're supposed to do. During the course of all this, several text messages have been released. It's been a lot of messages that have gone back and forth, of course, between these two because they had a relationship. And these messages, they've gotten, they're kind of explicit. Okay, so one text was released. The alleged victim, she wrote in a message on June 14th, 2024, "I want to be abused, daddy." In a separate text message on July 6, 2024, the woman wrote to Sharpe, I want you to tie me up like this and abuse me, daddy, accompanied by an explicit image of a male and female performing an intimate act. And then the alleged victim texted Sharpe on January 31st, 2024. I want like some hardcore BDSM action though.
Do you know what that means?
BDSM?
Yeah. No, don't pretend like you don't know. Bondage.
There you go.
That's the word on the street, bondage.
Okay. Do my research. I found that. And amid the release text messages, there appeared to be one from earlier this year on January 2nd, the same day the woman says that she was raped by Sharpe in her lawsuit, where she confronted him about the alleged assault. And it says, "But I cried when you left because I begged you to put a condom on and not put it in my ass, and you didn't listen," she texted him. "I don't care what our history is. No means no, Shannon." That's not good. Well, she also texted him, "I don't know how to process this." He replied, "Can I call you later?" It wasn't clear from the release text messages whether they discussed what had happened on the phone. The messages came on the heels of several text messages shared by Shannon's team on Monday, in which she asked Sharpe to put a dog collar around my neck and tie me up and do bad things to me. So,
well, you said one thing that sounds bad, but think about it. If, and I'm just thinking of this from defense attorney's side,
right?
If she knows that I want to get this guy for money,
yep,
she's gonna text him,
sure,
and she's gonna text things that's gonna help her case,
sure,
knowing that he doesn't know that, so
right.
he's gonna respond a certain way. So that's an approach the defense counsel can have, because she's setting a foundation up for it. Secondly, of course, no means no, but I know the plaintiff is going to say hypothetically, they've had this type of sex 100 times. That one time, no means no. He's going to focus on that one. But defense counsel is going to focus on the 99 other times that she consensually did this type of sex activity.
Right.
And knowing that, humans are humans, there are humans who are going to say, whether it's right or wrong, it's okay, 99 times, and this one's, your credibility, they may not find your position as believable.
Yeah, and be clear, no means no. Whether it's 1,000 and 1,001st, you say no, that's clear. But what strikes me as unusual about the text messages, the text message came, but we don't see a response from Sharpe. Now, if a young lady texted me this, I will say, whoa. I will respond, whoa.
That's true.
That's not true. Why are you saying this? You said it was cool. You're worrying me,
Well, what are you talking about?
Right. What are you talking about? But I don't see a response. So that's why I said, well, that's not good. That's not something just like, oh, well, what's for lunch?
Well, that's assuming that we have all the texts.
Right. And that's also the other thing with text messages. Of course, people, in some of our cases, people will give us selected messages, delete others, and cherry pick certain messages and not have them all. And also, maybe just because the alleged victim, I believe, is only 20 years old. This is something pretty serious.
I think she was 19 at the time.
Yeah.
They're like 35 years apart. I got to comment on that one anyway.
Yeah. But this is something pretty serious to text. I mean, if this is what happened, you think you want to talk about this in person or call someone?
That's true.
I'm not gonna text. I'm not gonna put this on a text message. But I'm older too.
But here's the thing: is only 19, but. And like I said, I'm looking through the defense side of it. Well, she's not a child.
No.
She's 19.
Legally, no.
Yeah, and she admits to having some, at least, consensual sex of this type with him. You're 54, a person's 19. You got to be smarter than that. You know what I mean? You have to. A person is 35. You have to pursue people who are equally yoked as you.
I don't like to put generalizations on age. I think a lot of people do, some people say, half your age plus 15, then it's okay. I think it's going to really depend on the person. And of course, that is a huge age gap, but maybe, I don't know. For me, I don't think I'm going to click with a 19-year-old. We're not going to have a common story to discuss.
Yeah, I'm going to be talking about Led Zeppelin and Boogie Down Productions.
Yeah.
I'm like, what's she going to talk about?
I don't know. But the other thing about it is it seemed like they weren't doing too much talking anyway. So if that's
that was a good closing argument, dude. I like that.
Right. Right. If it comes down to it, then the age thing is not going to really come into play on that regard. But for Sharpe, yeah, I think it's just a matter of discretion and intelligence.
You having a midlife crisis? Buy a Ferrari.
Yeah.
You have to be, and I understand, 19. But my thing is that you got to be wise in your decisions. Mm-hmm. Okay, you're 54, you're a celebrity, you have the wealth and stuff like that. What can you do for her? What can she do for you? There are people out there you can be a good mate, but you got to be a little more wiser in your decisions.
Mm-hmm. That's what this gray hair is supposed to bring is wisdom.
Yep.
Anything I say, you're just gonna get mad at, and you're just gonna hang up on me. So I feel like
I'm not gonna hang up on you. Here's what it is.
What does that even mean?
Nothing, Gabby. You want to be a dick to me now, so.
I don't want to be. Don't manipulate me.
Oh, Lord have mercy. If you say that one more time, I'm going to choke the out of you when I see you. Thank you.
Well, I don't want to be choked.
Yes, you do. I don't think you have a choice in the matter.
Okay, so along with text messages, apparently she was recording his phone calls too, which, if you don't know, the new update on the iPhone, to record a phone call, you just have to hit a button while you're talking to someone and it records your whole conversation. So
is it a crime in Nevada to record without another person's knowledge?
That's
what she did.
That is a good question. Every state is different. You either have to be a single or double consent to record a phone call. Every state is different. So in some states, it is in fact a crime to record someone without.
Here's the thing. After me doing my research about bondage, could this conversation be part of the role playing of bondage?
And that's what they have said. That's what Sharpe's team has said, that this was part, because the way she responded, say she didn't want to be choked, didn't sound like someone who was saying, I don't want to be choked.
Exactly.
It was I was like, whoa, what is going on here?
What the hell are you talking about?
I don't understand. I don't understand. But the conversation was unusual.
Yeah, because part of I'm assuming the turn on is a person who says, I don't want that to happen. Mm-hmm. But yeah, the whole bondage thing is a force thing.
Yeah,
you know what I mean. So
I think what's gonna probably end up happening in this case is gonna settle. I don't think they're gonna go to trial. I think it's just a lot of.
They turned down $10 million.
Yeah, I think they're gonna just get more than. It's gonna continue. They're gonna go back and forth, blah blah blah, and then they're gonna settle. But I don't think it's gonna be a trial because I don't.
But here's the thing: if you settle, all this information that they've revealed, I'm gonna say leaked. They revealed it. Mm-hmm. That's already in the minds of people. So you're already tarnished.
Oh, absolutely, absolutely. Like I've said in the beginning, and I've titled our show, I'm a trial attorney. So every civil case that I do, I approach it with the position that I'm going to trial. That down the line, we're going to go to trial, which apparently is a difficult mindset to have in the civil world because a lot of them don't think in that way.
Well, if you show a mind to settle, then it shows weakness.
Sure.
So then they're like, okay,
Sure.
he's not going to fight.
Right.
But if you start off like, okay, we could do this.
Yeah.
So you always want to come from a position of strength.
Right. So in particular for this case, what I would do, I would file, first I would probably file a motion to preserve any evidence, right? Because what's going to happen is, if it hasn't already happened, both sides are probably hurriedly destroying things.
Oh, they went to Costco and got that paper shredder.
Yeah, they got the shredder. They're hurriedly destroying things. So in essence, you want to make sure evidence is not a spoliation motion, or you want to make sure you go to court, say, judge, order both sides not to not to destroy anything, because it can be possible evidence later. So that's
Because you want the truth to come out.
Yep. So that's the first thing. But then after that, I would probably do a motion to dismiss. In the civil world, they exist in criminal too, but it's not really prevalent. But in the civil world, we could file a motion, say, boom, even from this piece of paper you filed, these complaints, these allegations, just from these words, it's not enough for it to move forward legally. That legally, you can't, it doesn't fit within the law to be able to prove your case. So the case should be over now. Sometimes those work.
So factually, what circumstances would you be able to file a motion to dismiss in this case?
Factually, in any civil case, you can file and say that the elements, or say, for instance, I think one of the charges is battery. You would look at the allegations they're making about the battery and say, from reading these words, the battery doesn't exist. There is no battery. There was no, even if we believed everything that's said here, it's still legally not a battery.
So if I swung a bat at you and missed, and they say battery,
Instead
and I
of
never touch you, like, oh,
exactly.
not a battery. It might be assault, but you claim battery.
Right, exactly.
Okay.
And a lot of times, that can be successful. And then after that, what I'm doing is I'm probably doing some requests or a motion to admit. And that's the discovery part, where I'm coming in and saying, I'm filing a piece of paper saying, look, you have to respond to this about these facts within 30 days. Otherwise, these facts come into trial.
Is that where you admit, deny something? I say, hey, she's 19 at the time. I admit it.
Right.
Was she in a dating relationship? I admit it.
Yep.
That type of
And
thing.
I'm putting those in, boom, 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 everything that favors my client. And if they miss the deadline or mess up, whoop, now that's admitted at trial.
Sounds like the fundamentals to me.
Yep. And, and from the beginning, I'm framing, what the theme of the case is. The entire process, with motion dismiss, discovery, other motions after that, I'm framing, during my depositions, everything that I'm doing is framing around whatever I decide the entire theme of the case at trial is going to be. So I'm thinking about trial. If this case was filed in April, it might not go to trial for 2 years, but when I'm defending the case in April, I'm thinking about the trial 2 years from now.
Yeah, that's why you don't get your client to get up there and say, well, we're claiming this is based on racism or blah, blah. You're throwing these theories out there early in the game.
Yep. And quite frankly, if I'm defending Sharpe and this stuff just isn't true, we're not settling. Why settle? I always tell my clients, look, you can lie to your mama, you can lie to your wife, you can lie to your priest, but don't lie to me. So if you're telling me the truth and you're like, look, man, I didn't do this. This isn't me. Even though I'm an attorney, I don't see a whole lot of scenarios where you tell the client, go ahead and give them $10 million for something you didn't do.
Yeah.
Just to keep your private life.
Yeah.
It's
not private anymore anyway.
No, it's not. It's not. So what is it that you are trying to protect, if not for your integrity in that regard?
Or what is it that you don't want to come out?
Yeah, something really. I mean, it's possible.
It might get worse.
Yeah, apparently it could. It might get worse. But yeah, if I'm Sharpe's attorney, we fighting, man. We going at it.
Well, let me answer this. Why don't a lot of and they tend to be men when they're accused of sexual assault and are sued civilly? Why don't they ever file a countersuit? Because you're being defamed. If you're saying this is not true, and you have a lot at risk, your reputation, your job. I think they suspended him.
Well, he says he took a break. That's what he said.
That's a nice way of saying,
Yeah. Yeah.
But what I'm saying is that affects you on all type of levels. Why don't a lot of people countersuit in these type of cases?
Well, I'll tell you why. Because, of course, a truth or a defense defamation is truth. So they're not filing defamation suits because they probably did what they're accused of. So if they file defamation and what they're accused of is true, then they lose the defamation too. And they probably have to pay the other side's attorney's fees. So,
But what I'm saying, he's saying it was consensual.
yeah,
She's
in this
saying
case,
it's
yes.
not.
Yes, in this case.
So why wouldn't he sue her for claiming that he did this criminal act?
Well, I agree. He probably should,
He
but
should, but why don't they?
because maybe what he's accused of, he did.
Or
That could
maybe
be.
could it be that they don't want to give the parents that they're beating up on her? You got this wealthy guy, is a celebrity. If I attack her and she has relatively no money, for
Well,
appearance sake.
I wouldn't even go that far. Apparently, she was OnlyFans, and she
Really?
she doesn't seem to be a shrinking violet in these.
That's what I'm saying. That's what I'm saying.
Yeah,
When you just say 19.
Yeah.
19 when I was 19 was 19.
Mm-hmm.
12 was 12.
Right.
But like I said, times have changed. I'm an old fuddy-duddy, but no, life has changed. People are more mature and they're doing more mature things. I mean, we were talking about, as the defense counsel for Mr. Sharpe, about what evidence did you seek and what evidence would you exclude. Mr. Sharpe did a video. He claimed, I'm an Android person, so I'm not an expert on iPhones, that he accidentally turned on this iPhone and recorded him having sex with a woman other than that's different from this young lady.
Right.
I think the plaintiff's attorney trying to get that in. I don't know if they're trying to say he has a propensity to do certain things.
Okay,
Would
right.
you try to exclude that?
Oh, absolutely. It's not relevant. It's highly prejudicial. And that's what we say. It's probative value versus prejudice. So probative meaning, is it really gonna show us anything? Is it really gonna help us reach a final conclusion on the case?
Or is it just going to dirty him up?
Yeah. And in this case, of course, would dirty him up. That's the only point in this particular instance, because the two instances are different.
Could that be a motive for her suing him because she discovered that he was having sex with another woman?
It's possible, but this doesn't seem like I don't know. This doesn't seem like a relationship where they thought they were exclusive. I don't know.
I've seen it.
I don't know how these things work when you tie people up in stores, but is that kind of a thing? Maybe she says we can only tie each other up. You can't tie up anybody else, or I don't know. But there could be a motive, yes, that she got upset about that.
I mean, something intimate like that, she may feel that it's just us.
Yeah.
And then I find out now, regardless of even though you may not having that type of sexual activity with her, that you're kind of cheating on me. I thought we were exclusive. I don't let anybody else tie me up.
Yeah, it's a possibility. So then, even in regards to after we, the pretrial motions are going to be excluding certain things, and for something like this, it's going to be long because there are going to be tons of text messages. Apparently, going to be ton of audio recordings. There are going to be tons of things. They're probably going to try to bring in things that Sharpe has said in the media, things he said in the past. He's all over social media on podcasts and sorts. They're probably going to try to bring in all sorts of different things. So that is probably going to be, to a certain extent, almost as important as the trial.
Yeah, they're going to go through all social media too.
Yes.
Messenger and.
Yeah. So, but then when you get to trial, is this something, Ricky, where you think you want to focus on the credibility of the witness, or do you want to attack, the veracity or these text messages and all of these audio recordings?
I mean, you're placed in a position where you have to do both. Mm-hmm. What you got to figure out is a balance on it. You never want. I just remember as a prosecutor, I would never beat up on like children.
Right.
You know what? You may challenge their ability to remember and stuff like that. Or they may have influence from adults. Certain sympathetic people, it's never going to work if you're going to beat them up.
Right.
With her, you have to find the balance. You do. That's why I said, I'm 61. You're a 54-year-old mature man with life experiences, and then you have a 19-year-old. But then you have to say, well, she's not the, it's like for lack of a better word, calling a thief without calling them a thief. You know what I mean? So you don't beat them up, but what I'm saying is, but you can reveal them through things they've said,
Right.
and things they did.
Right.
If this was so horrible, why didn't you go to the police and said he did these horrible things? So you have to do both, but you have to be delicate, and it has to be a balance.
Well, that comes with being an actual trial attorney. A lot of people in the general public, and I think even a lot of attorneys, think if I'm aggressive, I'm attack, and I'm loud and idiotic, then that makes me a good attorney. Of course, that's completely wrong. You have to know when and where to attack.
Yeah, I'm gonna give you an example. I had an attempt murder case, and I told my client, not a very sophisticated client, I said, just be calm and just answer yes or no. And I'll be there to clean it up. And what happened was the prosecutor was like yelling at, is it your blah, 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 all that, like on television. And he stood there and said, no, ma'am. And that nullified all, it emphasized how ridiculous that approach is.
Right.
You know what I mean? To, that television approach, like you're attacking the person and what I'm saying is true, versus you saying politely, no, sir.
Right. It makes a difference. So, in essence, trial attorneys, you always are going to have to chew gum and walk at the same time. It's not an either or usually. For us, it's usually both. You got to do it. You have to do all, and you have to do it all well in order to get, a good result for your client. So, of course, you're going to have to attack the credibility of this young lady. And I mean, she is a very, very, she's a young lady. But to me, still, like I said earlier, I'm not too. Hopefully, I don't know if the plaintiff's attorneys are going to play this up, but I'm not really feeling the age thing so much in that regard, because, if the plaintiff tries to play it up, I'm going to come back to the defense attorney and say, look, she is no child. Well, listen to this stuff.
That's true. But like you said, one of the things you always said is so true, that trials are won during jury selection.
Yeah.
Now, if you get an older conservative who person appears to be conservative, and you hear this 19-year-old who's saying she's doing all this, and you hear her voice, they were like, I don't believe a word she's saying. You know what I'm saying?
Yeah.
So just like you said, the mere age of itself is not enough.
Right.
Because you have people, potential jurors from different backgrounds, religions, and stuff like that. They may look at her in a bad light, like, look, what were you doing at 18? I'm 60 years old. I've never done any of this. I've never heard of this. So they can't pop the champagne thinking that they're just going to present her as this 19-year-old virgin. It's just not going to happen.
Did you and Shannon offer to settle these accusations?
Yes, there was a settlement offer made by Mr. Sharpe. I will only generally say to you that it was in the tens of millions of dollars demanded by the plaintiff in return for her silence. That's under any definition commonly understood. That is blackmail. And Mr. Sharpe was willing to pay an amount in the tens of millions of dollars, but no final agreement could be reached. And we thought we were still in the middle of discussions when, without warning, the mediator, who's a retired judge, ourselves as lawyers, without any prior warning, still thinking that we were close to a final agreement, the plaintiff and her lawyer from Houston filed a case in Texas, publicly accusing my client of lies and willful, harmful lies by using the rape word when it was she knows, 100% knows, and the evidence will show that she knew that this was entirely consensual. So we were of the belief on our side that we had an agreement without any warning. Not even the mediator, who is a retired judge, was given a warning out of courtesy. This case was filed and the public charges went throughout the media before we even knew that the discussions were over and the case had been filed.
Mr. Davis, last Friday, Front Office Sports reported Mr. Sharpe was in line for a $100 million deal for his podcast. On Sunday, the lawsuit was filed. Is there a timing issue here?
This is one of those two facts line up one after the other where everyone can draw their own reasonable inference. So I have a reasonable inference. It's my reasonable inference. Others might disagree that they're very related, that this plaintiff was looking for money. What she does on OnlyFans was for money in role-playing and virtual fantasy with men who pay her. At the end of the relationship, it's not known yet, but it is a fact that the plaintiff started to charge Mr. Sharpe money, so the relationship became transactional. This is who she is by the facts. I'm not saying it's good or bad. I'm just describing two facts, that she charged him money or asked for money. She's on OnlyFans and charges people money to do role-playing, and that for that reason, I'm going to let the inference be decided by everybody that her knowledge that Mr. Sharpe was about to receive a very lucrative contract based upon his talent and his abilities, and he's extremely capable on television and very knowledgeable, not only as a great former professional athlete, but I believe as a very credible and likable television presentation, that he has great value in his podcast and his positions on television. She knew that, took advantage of it, and I have described this in my opinion, it's my opinion only, that this is classic definition of blackmail, especially when you know the party you're blackmailing is about to be making a lot of money. In my opinion, that gives the greatest leverage to a blackmailer, and I believe there's a reasonable inference that one led to the other. Others might disagree. I'm sure Mr. Busby would make his own argument that this is not blackmail and that this is reasonable and that there's nothing to do with Mr. Sharpe's sudden announcement by somebody else, not by him, about a lucrative contract, had nothing to do with the plaintiff suddenly deciding to break off negotiation after she was offered tens of millions of dollars and suddenly to file a lawsuit. And why she did that and why her lawyer did that is up to them to explain.
The next question is coming from Edward Lewis from TMZ. I just want to be clear, Mr. Sharpe did make his accuser an offer in the tens of millions of dollars range, correct?
In the multiple of 10. That's all I'm willing to say at this point. But yes, the answer is yes, in multiples of 10 million, more than 10 million. I'd like to condition my last answer as I was not in the room for the mediation effort. It is possible it is only 10 million as the last offer. So I'll at least say at least 10 million, subject to my confirming whether there were any numbers exchanged higher than 10 million. So let me correct what I said, that it's at least a $10 million offer that had been made and that they walked away from.
Just in that recording, we heard Sharpe's attorney, and he was talking about settlement. But one thing that I think a lot of times is being left out in media coverage is there was a mediation. So mediation is where even before anything is filed in court, before you even bring forth the complaint to get it in court, both sides agree we're going to go in front of a neutral person. They usually retired judges, or sometimes they're attorneys, but more often than not, they're retired judges who were judges forever, and now they sit in a room. Both sides are in separate rooms, and the judge goes between the two rooms and discusses the case. And then after the judge does that, at the end, the judge will say, okay, I recommend that this case settles for $10 million or something to that effect. Now, what the judge says, it's not binding, meaning that no one has to do it. But more often than not, when both sides agree to go to mediation, that means that you're really saying, okay, whatever the judge says, the retired judge says, that's what we're gonna do, that we're gonna agree to do that. So it sounds like what happened in this case, that Sharpe and the plaintiff's attorneys win the mediation, and the retired judge came out with a number around 10 million, and then the plaintiff's attorneys rejected that and filed the lawsuit.
But they filed it after they discovered that he got this $100 million contract with, was it ESPN or some other?
Yeah, $100 million for somebody.
So that's an implication that once they discover that, $10 million, that's mug money. He's making $100 million. Well, do you know what mug money is?
Mud money?
No, mug, like you're being mugged by a person.
Oh yeah.
Mug, $10 million let me just give her this $10 million. But mug money was, say if you carried $5,000 on you.
Yeah,
you
extra.
You keep it in your sock,
Right.
but you keep 20 in your pocket, and
Right.
when the guy comes, you give him the $20
Right.
so he can leave you alone.
Mm-hmm.
So it seems, do you think it's a good idea for someone like Shannon Sharpe to even have this? Because when people hear this, they're going to say, well, if you didn't do anything wrong, why are you negotiating?
Yeah, that's the way I look at it. I don't see, it's tough for me to see a situation where if you did nothing, that you would give $10 million. I don't care how rich you are.
Yeah.
That's a lot of money.
A lot of money.
That's not a little bit of money. But on the other side,
And that's more than a lot of money for her.
yeah. Well, I don't know. Apparently,
Yeah, you're
facts
right.
are coming out that
Yeah.
she does OnlyFans and that she was charging Sharp and she's charging people for virtual BDSM. I mean, she probably made more than me.
She made more than you.
Yeah.
And me together.
Yeah. So, but I think even on the other side, I think that's a huge risk by the plaintiff's attorneys to turn down
Absolutely.
$10 million because you think you're going to get more. That's a huge risk.
Exactly.
That's a huge risk.
One is you're going to get the $10 million, and you might not get the whatever you asked for.
Yeah. So, I mean, to kind of wrap this up, we could talk about at trial again, what are going to be the issues. And a lot of things at trial, a lot of this case is going to be based on kind of the pretrial motions, what comes in, what doesn't come in, what text messages come in, what text messages don't go in. Because this isn't a case where they're not going to be, I can't imagine they're going to be witnesses, really, other witnesses, because this is private information. So the only witnesses they could probably have on the plaintiff side are what we call outcry witnesses. Maybe she told some of her friends or family that this was going on, and then they're going to try to bring in those outcry witnesses to try to testify on her behalf. I can't really think of any sort of eyewitnesses or
Only fan witnesses.
yeah, it could be, or other types of witnesses for her or Sharpe for that matter. This is going to be a case was going to really be him versus her. She said versus he said.
I got a question. Remember the game shows where they said you can have this $10 million or what's behind curtain number 2.
Yeah.
Take the $10 million.
Take
It did open up as like a case of turtle wax.
Right. Take the money.
Take the money.
So one hurdle they're going to have with civil cases, the standard is preponderance of the evidence,
Which means
it's more likely than not
that it happened.
that it happened.
Okay.
So it's easier for the plaintiff to prove their case. This isn't a criminal; it's beyond a reasonable doubt, which is much higher standard. So high we can't even quantify it.
What I mean, by law, you cannot even define it.
Right.
So I think the mistake they make is if you say you can give people jury instructions to say you have to show this more likely than not, but people are gonna take the whole human experience like, I just don't believe it.
Mm-hmm.
They're not gonna do that qualification.
Right.
They're not gonna qualify it. Like
Yeah. But I mean, legally, any sort of legal precedents or any prior cases, nothing is jumping into my head in regards to the civil realm and these sort of things. This isn't one thing that could come up could be argued. Maybe character witnesses would be able to come in because even though usually those kind of cases, you got to say, well, somebody's questioning my morality or my character in general. So usually crimes like moral turpitude, like theft,
Okay.
or something along those lines. But something like this, if I'm Sharpe's attorney, I'm arguing, look, that this is attacking my character. This is saying that I've done these horrible things. So maybe, it could be risky on his part, but maybe bring in other women he's done similar types of things with, and say, "You cool? Yeah, we're fine with it." He always followed my wishes. We had agreements. He stuck to those agreements. There were never times where these sort of things. Maybe do that. I don't know. It's a risk, but maybe that's something you want to look at too. But I don't think it's going to trial anyway.
Really?
Nah, it's gonna settle. They're just gonna give more money.
So they're eyeing like, okay, the $10 million wasn't good enough for you. Okay, I throw you 20. Get out of my life.
They're gonna get more money because when it comes down to it,
It's all about the money.
well, it's not even all about the money. The stress of trial is a lot too much for many people. This guy's even though he's a professional athlete, generically he's tough physically, but what about mentally?
Yeah, I remember we did a murder case, and I remember, he was the guy who's, if he was found guilty, was going to die in prison. But just me as the defense attorney, it was draining.
Yeah.
I mean, you physically and mentally exhausted. Mm-hmm. So sometimes what's in the best interest of your client is say, maybe we need to try to settle this.
Mm-hmm. Yeah, and I think that's what's going to happen here, because I don't think Shannon Sharpe is going to want to take the risk at trial if they lose. I mean, who knows what the jury gets to decide the amount.
Or at the same time, you don't want all this other stuff coming out either.
Mm-hmm.
You know what I mean?
Yeah, that's true. But we'll continue to follow this case. We should be able to get our hands on the actual complaint at some point, and we'll see. We'll see how this unfolds. But this is unfortunately an unfortunate fact in our world today. I don't know. Maybe these celebrities, these cats need to talk more to their attorneys. Man, they need waivers or something. I don't know.
What I'm saying is, I'm gonna go back. Like, I'm 61 years old. You got to be smarter than that. I mean, come on. Don't put yourself. I'm not trying to say whether it's happened or not, but you always have to especially if you're a celebrity, you have money. You can't do those same things as just the average person on the street.
Yeah.
You got to be smarter than that.
Yeah.
I mean, you should even talk to your attorney about, dating a girl who does bondage. I mean, seriously.
Yeah, you should.
Get to the point and say, how do I protect myself?
You should. If you have those type of resources, you should do it. Now, if I work at Foot Locker, I probably don't have those types of resources.
Exactly.
But and I'm not knocking anybody working Foot Locker. I mean, you get discount on shoes.
Or you talk to a 61-year-old guy who's experienced life, say, don't do it, dude.
Right, don't do it.
Don't do it.
Don't do it. It's always that one guy. Don't do it.
What I'm saying is, but there are people who either have life experiences or legal experiences. They can advise you, that don't sound like a good idea.
Yep. So Shannon Sharpe,
Unc. He's grand unc. She's not.
She is
grand unc.
She is grand unc. We'll see how this works out. But as always, these cases are interesting to us as actual trial attorneys, and we'll see if it goes to trial. If it actually goes to trial, I'll send a message to Shannon Sharpe and say he can tackle me. if it actually
with
goes
them knees, I don't think he'd be able to get.
I don't think he's gonna.
I think you're gonna be able to get you.
All right, so that's another episode of Trial Attorneys. Appreciate you viewing, watching. Subscribe, like on all the social media platforms, and appreciate that. Thank you.